What a day. Hey, thanks, Sam, for sending over your audience. Thank you so much. Um, so we have a Salvador raid. Yay. And hello, you over at the Rumbles, or the handful of you, or something like that. Yeah, I have my poll up at YouTube's. How late do you think the judge was today? Give me your votes. Give me your votes. Oh, Dali and Dali and E-Raid. Yeah, you're raiding Vikings. Welcome. Teleported. Dali and E-Raid. Yay. Thank you. Yeah, January 2nd. And Mr. Stillwell is good enough to sit down and listen to all the testimonies. So we are resuming, which means that the stream on the Maricelo Botello murder trial will be going on after this. And because this is more of a recap. And yeah, because today's court, so many breaks, sidebars, and judge was late. Not uncommon. Yeah, I got home 10 minutes ago, so I'll be eating meanwhile. I'm having meatballs, potatoes, gravy, and lingonberry. Warmed up since yesterday. Man, we are coming from a sales stream, so saying you have your polo up is brave. Oh, and hello, sorry in pickle over the Rommel. Good to see you. Good to see you. Sweden is very windy today. Not hurricane windy, just annoyingly windy. Okay, you have had a few minutes to vote, so let's bring this up. And the winner is... yeah, 45 minutes. 45 minutes late. Of trial day that should have started 9:30, started 10:15. Yeah. This... they really can't. They really can't. Now, what's on the menu today? Well, they're going to start off with the security guard from the mall. And it's about an alleged... they were on hoverboards, didn't listen to the security guard, but they left eventually, and then stories go apart. But we will at least listen to this former security guard who sadly had a stroke in 2020. Now, having a stroke, his kind of stroke is he has problems articulating words, the speech pattern. There's nothing wrong with his brain. But just so you are aware of that when he gets on here. But we are here. We are... oh, did Lawrence Seaward change the logo? Oh, let me change it again. Let's make myself bigger. Yeah, there, that's good. All right, are you ready? Trial day number 12 out of what will be probably in the 200s. No, not solely his speech pattern, but he has 3 years of physical therapy, and but still, it's speech. That's what's left. His mind is clear. He just have issues talking. Okay, let's go.
All right, thank you, Sergeant. Ladies and gentlemen, please be seated. All right, members of the jury, how we doing? Happy New Year to all of you. Happy New Year. All right, that's one for y'all. Sound good. Good. I hope you all had a good period of respite, and we're going to go ahead at this point in time continue with the presentation of the state's case. As I mentioned earlier, we'll go ahead and by the end of business today, we'll go ahead and take up kind of our plan for the next 2 or 3 weeks to kind of give you some indications as to now since the beginning of the year. I'm sure that there are other things that you need to kind of business-wise you need to take attention to. So I'm going to give you an opportunity to do so. So we'll talk about that.
He's in court.
Certainly.
So
end of the day or no later
3
than
weeks
tomorrow. Okay?
later, he's in court again.
So with that, State, if you call your next witness, please.
Thank you, Your Honor. Your Honor, today we're continuing with Act 51 was left off. This they call Dwight Hutchins.
All right, Simon Dwight Hutchins, please. Yeah. Can he? Oh, if he can't stand up. Okay, we'll just see how it goes. Mr. Hutchins, good morning, sir. Come on up. Mr. Hutchins, would you prefer to say where you are? Would you like to be assisted into the witness stand? Your choice.
Yes, thank you.
Okay, all right. Let's see if we can. We're going to turn you so everybody can see you. Okay. To begin with, is that okay?
Hey.
All right. Christine, you okay?
Yes.
All right. All right. Mr. Hutchins, let me get you to raise your right hand if you're able to do so, sir.
Raise your hand. You
All
swear.
right, go ahead.
You swear affirm the testimony you give today the truth, the whole truth, nothing but the truth?
Yes.
Speaking to the mic.
Yes.
All right, state and spell your first and last name for the court. So you go to your head down. Speaking to
My first name is Dwight, D-W-I-G-H-T. My last name is Hutchins, H-U-T-C-H-I-N-S.
And good morning, Mr. Hutchins. How are you?
I'm good.
And happy New Year to you.
Thank you.
Mr. Hutchins, do me a favor. I want you to yell in that microphone, okay? So we can all hear you, all right? Or I put it this way, use your outside voice. Let's see how that goes. Can we do a test?
Testing.
All right, okay. Just try and keep that level up if you wouldn't mind for us, okay?
All right.
All right, thank you, sir.
And Mr. Hutchins, where are you from?
Atlanta, Georgia.
All right. And do you currently reside within the metro Atlanta area?
No, I live in Loganville.
Okay. And how long have you been in Loganville?
I'm like a year and a half.
You said a year and a half? Okay. And are you currently working?
No,
Why aren't you working?
because I had a stroke
How long ago did you have your stroke?
right back when COVID started, 2020.
And with you having a stroke, has it affected your memory at all?
Yes.
Now, let me ask you, prior to having a stroke, did you work?
Yes.
What type of work did you do?
Security.
And how long were you in the security industry?
Give or take about 25 years.
And while in the security industry, did you ever work for Velour Security Services?
Yes, I have.
And if you can recall, approximately, when did you work for Velour Security Services?
About from 2013 to 2015.
And when you worked for Velour Security Services between 2013 and 2015, did you have a particular location that you were responsible for securing?
We secured the whole mall,
And we say the whole mall, which mall are you referring to?
Perimeter Mall.
And did you work at Perimeter Mall for the entirety of that 2013 to 2015 period?
Yes.
When you worked at Perimeter Mall, what were some of your job duties and responsibilities?
To help out people to go to accident scenes, wherever they may be.
You said to go to accident scenes? And you shook your head, is that a yes?
Yes.
And is that accident scenes within the mall?
Yes.
Did you ever have the responsibility for patrolling outside of the mall as well?
Yes.
Within Perimeter Mall, was there a particular unit or area where the security team was housed if you weren't patrolling? Did you have an office area?
Yes.
And in that office area, was that a shared space or did you have your own individual office within the security office area?
All of the officers shared that area.
And was that area a secure area?
Yes.
And just generally, if there was an incident that occurred at the mall, say an accident or anything like that, would you have to make an incident report, an internal incident report?
Yes.
And generally, when there was, say, an accident at the mall, did you always have to call outside law enforcement, or was that only on certain occasions?
No. It was only in certain occasions.
Why would you have to call law enforcement out?
If somebody slipped and fell and hurt themselves, well, catalytic converters, things of that nature.
And we say catalytic converters, what do you mean?
They were cutting them off.
They would cut them off at the mall.
Yes.
Like people would come up and cut off people's catalytic converters.
Yes.
If there were any crimes like theft, would you have to call the police?
I wouldn't have to call him per se.
Who would have to call?
Mr. May.
Mr. May. And who was Mr. May?
He's the director of security.
He was director of security. And was Mr. May your director of security the entire 2 years that you were at Perimeter Mall?
Yes.
As your supervisor, what was some of his responsibilities? As Mr. May, he was your supervisor?
He was over the whole department.
And do you know, as his job over the entire department, some of his responsibilities?
No.
Would he sometimes be called to assist you if you needed assistance?
If I
Yes,
called him.
yes. Yep, this is a state witness.
Now, when I direct your attention to July of 2015, were you working for Velour Services at Perimeter Mall?
Yes.
And taking you back to July 2015, which is a while ago, did you have the occasion to encounter a group
It
of
will
men
be
on
the
hoverboards?
state's case for
Yes.
around 5 months.
If you can tell the jury, what do you remember about your first encounter with them?
My first encounter was when I spoke to him, I explained the policy that it could be injured and liability issue. One guy stepped down, and then the other guy said, get back on your board.
So how many guys were on hoverboards?
So,
And you were explaining to them why they could not be on hoverboards?
yes,
And was that part of the mall policy why they could not be on hoverboards?
yes, due to liability issue.
And I believe you just said, I just want to clarify that when you spoke to them, one person got off the hoverboard, the other remained on the hoverboard. And you shake your head, is that a yes?
Yes,
And the one who stayed on the hoverboard, I believe your testimony was, he told the other person to get back onto their hoverboard.
correct.
Once that occurred, what, if anything, did you do as it relates to those two individuals still on their hoverboards?
I just kept explaining the policy.
And did they say anything to you as you kept on explaining their policy? Your policy, all.
They said they were leaving.
What was their demeanor?
I got toward me. It was all right.
I'm sorry, say that one more time.
Toward me, it was okay.
Towards you, it was okay. All right. Now, when they did not get off of their hoverboards, what did you do?
I called Mr. May.
And why did you call Mr. May?
That's for his job. When I can't help something, I call him.
When you can't do what?
Handle something.
And when you say you can't handle something, what couldn't you handle with this particular incident?
Well, they kept riding, and I ain't gonna put my hand on nobody. So I called him. Let him explain it to him.
And were you able to reach Mr. May?
Yes.
All right. And did Mr. May, what happened with Mr. May?
He asked my location. Then he came to my location.
All right. And what location were you at the time?
Champs,
And what type of store was Champs?
a shoe store.
And when Mr. May got to the shoe store, what happened?
I advised him of my situation, and he went and spoke to him.
And what happened when he began to speak with them?
They were leaving, so he said they're leaving anyway.
And what was their demeanor like when they said they were leaving?
I mean, I don't know what you mean by it.
Okay.
Were they hostile or what?
Yeah. How were they acting?
They were acting normal. They were just riding.
They were just riding. All right. All right. And did they get off the hoverboard?
No.
All right. What happened next?
We escorted them to the front of the mall, up the escalator.
And were they still on the hoverboards when you
Yes.
put them out the mall?
Yes.
All right. And what happened after you escorted them out the mall?
We escorted them to the valet where they were parked.
All right. And did you go down to the valet area where they were parked?
Yes.
All right. What happened once at the valet area?
During that time, I got checked out because we already got them at the mall, so it's all good.
Okay. You said you checked out because it was all good at that point. All right. Did you hear them saying anything at that point?
I just heard a lot of profanity.
And who was giving profanity?
I'm not sure.
Oh, you don't know which one. Okay. Do you remember anything specific that they were saying?
No.
And you said they were yelling profanity. Was it the individual in the hoverboard yelling profanity?
Just guys in the car.
Just guys in the car. How many guys were in the car?
3 or 4.
This witness
And
had
you
a
don't recall what they were
stroke
saying?
3 years ago.
No. Okay. Now, back in 2015, did you have to make a report to the police regarding what happened at the mall with these 2 individuals on hoverboards?
I don't think they were in a police report.
Did you ever remember talking to the police about what happened?
No.
You don't remember? Okay. Do you ever remember writing a statement?
No.
Okay. Do you ever remember seeing a statement with your signature on it?
Yes.
All right. Permission to approach, Your Honor?
Give me that.
I believe the defense counsel all has this statement, but I'm going to show this to Mr. Hutchins. Mr. Hutchins, I'm going to show you what's been marked as State's Exhibit
Going down
190P.
because you want to hear this.
And looking at State's Exhibit 190P, do you see your signature on State's Exhibit 190P?
It looked like man, but it's not man.
It looks like your signature, but it's not your signature.
It looks like his, but it isn't his. Now, we do know he has memory issues. We do know that. But he's on the stand under oath. And you do recognize your own handwriting, in my opinion. Unless the prosecution has a doctor on that can testify to that. No, of course, this is his handwriting. Or a handwriting expert that can say with a certain degree of probability. Spoiler, they don't. No doctor, no handwriting expert to impeach or refute this gentleman's statement. That is not his signature.
Signature.
That's how I write now.
That's not how you write now.
I write like this now.
Okay, but back then, you're saying, but back in July of 2015, that's not how you wrote.
No.
All right. Let me ask you, looking at that document, though, that has your name on it, is there a date indicated on that document?
Yes.
Yes. Yeah, do you have an objection? Yes. Basis.
Document is in
Faces.
A document has been disowned. There's no foundation.
Foundation, okay, that's what we're looking for. All right.
Your Honor, it's impeachment.
Yeah. The prosecution wants to impeach the stroke victim. Now you can, but you have to be careful if you don't want to be seen as a complete asshole. Now, can you give me a guess if this prosecution cares if they might be seen like a complete asswipe? Press 1 for yes, she is very careful in her impeachment, moving on. Or 2, she doesn't care.
And he's saying I don't want to do a speaking.
Okay, all right. I'm gonna overrule your objection. So you may proceed this time.
Is there a date on that document?
Yes.
Okay, what is the date?
7/7/2015.
Okay, and in looking at the document, you've had opportunity to read this document previously?
Yes.
Okay, and is this document written in first person, meaning as if you wrote the document?
Your Honor, same objection.
Given what I've learned already about the witness, I'm gonna give him a little attitude, Mr. Steele. I'm gonna overrule your objection, okay? Ordinarily, I wouldn't allow them to leave, but I'm gonna, in this particular circumstance, make an exception, okay?
Is it written in first person?
Yes.
Okay, and so it says I, Officer Hutchins, right?
Correct.
Okay. And this document also has a date in which it was written, right?
Yes.
What is the date that the document was written?
July 7th, 2015.
All right. And this same document was written closer in time to the incident that we're referring to, which was July 2015.
I can't say.
You can't say, but there's your signature.
It looked like my body number.
All right, and there's a date of July 7, 2015.
Ask and answer.
I stand in objection.
And today you're saying that you did not write this statement.
I don't recall
You don't
writing
recall.
this statement.
Okay. All right, and you do not recall writing the statement.
Correct.
Okay, thank you.
Who made that objection? I'm sorry?
Yeah. Here is what the prosecution does. He answers he didn't write it. Then she leads him in by saying, oh, you don't remember writing this statement? Yes. Yeah, she's an ass, in my opinion. Does he have memory problems? Yes. But if his testimony, if she drags him into court to sit down and testify, she's doing this with malice, in my opinion. If he doesn't answer the way she wants, she will try to make him answer as she wants. We will get there. And that's the hard part of this. She brings on 3 police officers to call this man a liar. 3 police officers. Instead of bringing in his boss, this gentleman's boss, and say, yes, this is the statement he wrote that day, and get on with it. No, she brings him on to humiliate him. He probably did, but he had a stroke, so he has memory issues. And there are ways to get around that. By having his boss testify to, yes, this is the one he wrote. Are there still foundational issues with that? Yeah, sure. But they will still get it in. If the boss and the cop testifies, yes, this is the report that was written by this gentleman. He has too much memory loss to be a foundational witness. Instead, This bitch is bringing him on to humiliate him, in my opinion.
Objection as an answer.
I sustain the objection.
Now, a few weeks ago, do you recall one of my investigators coming to your home?
Yes.
All right. And when my investigator came to your home, did the individual show you this document?
On his phone, yes.
Okay. And do you
He showed the document, A4, on his phone to a stroke victim. Do you recognize this? Ass.
recall what you told him about your signature when he showed you the document on the phone?
Correct.
Okay. And what did you tell him about your signature?
I said at that time, it looked like mine.
Okay. And this same signature, was this the same document that he showed you on the phone?
It was so small, I could not see it, but it looks to be the same.
It looked to be the same document. Okay.
Yeah. So they did knowingly go over to him, not with an actual document, but have him look on a screen on a phone on the document. They need to impeach his memory about writing and signing this document instead of finding a solution. He was the security guard at a mall where allegedly a bunch of kids drove on hoverboards inside the mall. He asked them to leave. They went freely outside. Outside were 3 or 4 people in a car, and then stories split. What was actually said from that car. The prosecution argues they were death threats from that car. He says he only remembers profanity. And there's nothing in his report that says he was had a death threat against him. So that is also an impeachment against him. And they bring on 3 cops to argue he is lying about his signature. He has memory loss, and therefore you shouldn't count everything in the document as true, because we heard from witnesses that there were death threats. And when cross-examined one of the police officers, well, where in your report does it say the witnesses where in your report does it say witnesses heard a death threat? And it didn't in his original report. So he testifies to it instead. And somewhere there is a document about a witness claiming, yes, he heard death threats. It's so shady. It's so extremely shady. But let's keep listening to this guy's testimony.
Now, Mr. Hutchins, as it relates to, you said that you kind of had to escort individuals from the hoverboard out of the mall. Was this your first time ever having to escort anyone out of the mall?
No.
And when you previously had to escort individuals out of the mall, do you always have to call the police when you're trying to escort individuals out of the mall?
I sustain the objection.
On this incident day, back in July 2015, were the police called after this interaction with the individuals on hoverboards?
Yes, they were called, but I didn't call.
You did not call, but they were called.
He didn't call them. Somebody else called them. He, who escorted the kids out, heard the profanity, didn't think it was enough to even write the supposed death threat in his report. They left. They left. But his boss called the cops. And the boss is in his full right to call the cops. Does the boss take the stand? No, he doesn't. Prosecution chose to call the stroke victim and then impeach the stroke victim.
All right. Now, back in 2015, when you first encountered the individuals on hoverboards, did you know their names or who they were?
No.
Back in 2015, is it safe that you had never met those individuals prior to that interaction that you had with them on the hoverboards?
Correct.
All right. And at the conclusion of the interaction with those males, did you learn their names at any point in time?
After they left the mall,
How did you learn their names once they left the mall?
well, they are people that recognized them.
People at the mall have
Some people at the mall claims they recognized the people in the car. Because as you all know, eyewitnesses from a certain distance are the best kind of evidence, right? Right? Wrong. Eyewitnesses are horrible. You can have a person walking into a classroom with a blue overall and a green jacket. Stand there and talk to the students for 5 minutes, then walk out. Then 5 minutes later, the students can get a piece of paper where they're asked, what was his clothes? And you will hear the most amazing answers. You will hear the most amazing answers. Eyewitness testimony is horrible. Human memory is flawed. It's flawed. But, yeah, people near claimed they recognized the people in the car.
recognized them.
Right.
Coincidentally, the same people who said, oh, we heard a death threat. Right, we heard a death threat.
And who did you learn it to be?
Well, I don't remember the name.
You don't remember who it is. All right.
He said, I didn't learn their name. And she replies, the prosecutor replies, oh, you don't remember. For me, this is misstating his actual testimony, but they have to object.
I'm going to show you what's already been admitted as State's Exhibits 184P. I'm going to hand this to you. Sure. Yeah. Mr. Ernst, can I understand you for those?
Yeah, it's Mr. Stillwell here in the back in the... Or is it? No, that's the woman. Sorry. Well, he's back there somewhere. Sorry.
And Mr. Hudson, I'm going to show you right here. And for the jury's on the screen, State Exhibit 184P. Have you seen that picture before?
Yes.
Okay. And do you see yourself in State Exhibit 184P?
Yes.
If you can tell the jury, where are you at in State Exhibit 184P?
At the top of the escalator.
Okay. And at the top of the escalator, there's two individuals. Which one are you?
I'm the one on the left with the flight jacket.
With the flight deck, with the vest on? All right. And now I'm going to show you what's been marked as State Exhibit 185P. And have you seen that picture before?
Yes.
All right.
Yeah, they are making a whole lot of fuss about teenagers going by hoverboard in a mall. And then allegedly a death threat was said from a car where eyewitnesses claims they know who it was. And what they said.
And looking at Stacey Dillon 185P, do you recognize the individual?
This Rico-trial, and I said it before, and I will say it again. This is what the prosecution seems fit to take the court's time with. This day, January 2nd, they could have had 4 or 5 cases in and out, where victim and defendant had their day in court. Instead, we are watching this bullshit.
In 185P.
I don't recognize him, but that's the gentleman that I spoke to.
That's the gentleman that you spoke to. And when speaking about the 2 individuals, initially one stayed on the hoverboard and one came off the hoverboard. The individual in 185P, which one was he?
He has issues forming the words. But he is clear in the head. It's just when he has to think of the word and then say the word. And sometimes it comes out wrong. But yeah, I mean, he is a stroke victim. And he has memory issues. We know that. So why the flaming F is he on the stand? Yeah, to admit a piece of paper that I believe his boss and the reporting officer could have testified to, everything around it, and give the foundation for this document. But no, the prosecution just has to have the stroke victim on the stand to humiliate him. It's pissing me off.
He was the one that said, get back on your hoverboard.
Okay, so he's going to stay on the hoverboard and direct the other person get back onto the hoverboard.
Yes.
Yes. Okay. And down at the valet, when you said that people were cussing, was he one of those individuals that was cussing down at the valet?
I don't know.
You don't know.
I didn't see him per se.
Okay. So that's your testimony today. You did not see him per se.
Because, like I said, once we got him out the building, I kind of checked out because we had already done our job.
Okay. And you were the one who first had the first interactions with these individuals?
Yes.
And you were the one who called Mr. May?
Yes.
All right.
I'm over the leading. I'll sustain the repetitive.
I have no course indulgence.
All right.
Court indulgence.
Earlier, you just one last question, Mr. Hutchins. Earlier, you said that the demeanor, earlier, you testified that the demeanor, that they weren't fussing and cussing towards you. Were they fussing and cussing towards anyone else earlier in the day? Earlier in your interaction?
No.
No, you don't recall that.
No, we're not.
Hold on, basis.
Again, he says no, she says, oh, you don't recall that. You are not a good person, lady.
I'm over the objection.
Also objection.
I'll rule the objection. I'll rule the objection as to yours. One at a time, gentlemen. Mr. Matthews, yours is overruled, or yours is, overruled. What's your objection, sir?
District attorney mischaracterized the answer.
I'm going to overrule your objection. Jury will be determine what they.
And he overrules it. This is clear characterization. He says no, and she says, oh, you don't remember, or no, you don't remember, or no, you don't recall. That's characterization. Yeah, exactly. She's testifying. And the judge just goes along.
What they heard, okay? All right, anything else? All right.
I have no further questions.
Any examination of Mr. Hutchins, gentlemen?
Very brief.
Okay, come on.
Question in that corner.
You may, sir.
Good morning, sir.
Good morning.
We all hope that you feel better and keep recovering.
Thank you.
Do you, have you read what was shown to you as a number 190P? It's that document that the district attorney was asking you if your signature was on that?
Correct.
Okay. Do you know where that document is right now by any chance?
No, the original.
Yeah, is that it? Your Honor, may I approach 1 second?
You may.
May I approach you, sir?
Yes.
I'm going to show you this, and if you can't read it, just let us know, okay? I see you with reading glasses.
I'm ready.
With your permission and the court's permission, I just want to ask you a couple of questions about that document, okay? The district attorney was saying that it was written. Is that a written document or a typed document?
It's typed.
Okay. And the only part written would be at the bottom of that document, is that fair to say?
Yes.
With a, I'm not saying, I understand, it's your testimony, purportedly, meaning potentially or seemingly your signature and then the date of 7/7/2015. Is that true?
I mean, let's go ahead again.
That's the only handwritten
Yes,
part
sir.
of 190P. Okay. And in that document, even the type part, you never mentioned anything about any of the people on the hoverboard being rude to you or Mr. May in the mall. Is that true?
Correct.
And what you do write is that you were being ignored and Mr. May was being ignored about your warning to please get off the hoverboard, and it could be a dangerous situation for them as well as others. Is that fair to say?
Correct.
And the people on the hoverboard made it known and they did leave the mall. Fair to say?
Yes.
And then they went peacefully to their car.
Yes.
And at that point, the way you recall is it was pretty much they were leaving. It was over. Any issue was over. Is that fair to say?
Yes.
Okay. But then in this statement, the 190P, it's written that Mr. May continued to ask them to leave the property. And I stress this, one of the males shouted he would come back and shoot Mr. May in the face. Do you remember that? Right, at least that's what it says. The last 2 lines?
That's what it says.
Okay. And you never identified anybody as saying that. You were just saying that it came from the car. Fair to say? If this is yours.
Well, all I can say was a lot of profanity.
Okay. All right. And you don't know, Mr.
His actual testimony in court is all he heard was a lot of profanity. He already says he doesn't write that, he doesn't sign that now, and he didn't had his signature was not like that back then. When the cops went, or when the prosecution's investigators went to him with the phone to ask him to look, is this your signature? According to him, he said, it looks like mine. When he got the actual paper in front of him, he says, that's not mine. It's dated and signed. Sometimes that's all you need. It's not the depth we heard where we're going off the metadata.
Jeffrey Williams, do you?
No.
And you don't know a performer known as Young Thug personally, do you?
No.
All right. Thank you so much for your time. I can take that from you unless you need to. Thank you, Your Honor.
Anyone else? Anything further from the state?
Mr. Steele has asked you if you knew Mr. Young Thug personally. Once this incident was over, did you learn if Young Thug was one of the individuals on the hoverboard?
Yes.
Yes, you did, but you did not know him personally.
No.
All right. And Mr. Steele asked you a lot about the statement that I asked you about earlier. And again, looking at Exhibit 190P, today your testimony is that you heard a lot of cursing. Looking at 190P, in that last line, what is in that statement regarding what the individual in the car said upon leaving the location? So regarding that statement, do you have any memory writing that statement?
No,
You have no memory writing that statement. And is your testimony today that you did not provide that statement to police officers?
I don't remember providing this statement at all.
Okay.
There's something wrong with it.
All right. Thank you.
The last thing he said is there's something wrong with it. That is him testifying there's something wrong with it. He can't remember it, but there's something wrong with it. As in, so it may or may not be his signature. Maybe it's his actual memory loss. But why is he then on the stand?
No further questions.
Anything further?
Don't get this word.
All right, anyone else? Okay, may Mr. Hutchins be permanently or temporarily excused as a witness?
He can be permanently excused.
All right, Mr. Hutchins, I'm going to permanently excuse you as a witness. Thank you for your patience with us. And please don't discuss your testimony with anybody except the attorneys in this case, okay?
All
All
right,
right, thank you, sir.
thank you.
Yeah. And what happens next is this cop saying, previous witness, well, I saw him. I showed him. He said, that's my signature. While the Mr. Hutchins said, it looks like my signature in that small phone thingy. So that was his role. Then it's this cop talking about the same mall incident, saying he spoke to the witnesses. And they told, yes, we saw these guys in the car. We say it's Mr. Young Thug. And the same witnesses say that he yelled somebody from the car, or Mr. Young Thug yelled, I'm going to come back and shoot you in the face. Then it's a sidebar. And here, during cross-examination, Mr. Steele asks him to point in his report presented to the court, where it says, this is he yelled, I'm going to shoot you in the face. It's not in there. It is in his other reports. Then they are taking a break. A long one because they were so late to start. So let's move on with this witness. So yeah. I mean, it's so ridiculous.
Starting. Okay, so let me just kind of just tell you where we are going to head for the afternoon. Which witness stand once you get there, turn and face starting.
Open number 3.
I so swear.
Absolutely. State spell your first last name for the court.
Richard Randolph. Richard Combs spelled Randolph, Randolph.
And good afternoon.
Good afternoon.
Where are you employed?
I'm currently employed with the Fulton County District Attorney's Office.
Oh yeah, this is another one saying previous witness was wrong. Another one. So the prosecution had to put on 3 people on the stand to humiliate that poor man. More or less calling him a liar. And all for, and here's the thing, that alleged I'm going to come back and shoot you, MFR, or something of that sort. One of these officers wrote the warrant to the prosecution's office. The prosecution's office looked at it and dismissed all charges. Nothing came out of it. Nothing. Nobody was charged. Nobody was arrested. Nobody even went looking for whoever it was in that car. But it's in this Rico trial. For half a day. For something the prosecution back in 2015 dismissed. But this is a Rico trial. And I've said it before, and I'll say it again. The Georgia RICO Act is so broad and so vague that they are using these as underlying acts in order to prove criminal conspiracy. This is a gang. And they are using case after case after case after case that were all dismissed. Nobody was arrested. Nobody was charged. In this case, this small incident, they can allege anything because they were never put on trial for it. They have never been able to defend themselves against these allegations in a court of law. Instead, under RICA as an underlying act, the prosecution brings it forward as if it is a proven fact. In my opinion, it isn't. Why? They were never charged. They didn't have their day in court. But that's the Georgia RICO. The prosecution can bring all of these crap charges just to paint people in a bad light. Now this officer, I don't remember what he said, so let's listen to this guy.
To the stand.
What's his last name, Ms. Ward?
Cogdale, C-O-G.
Cogdale?
Yes, L-L. Hey, Your Honor, we'll start on you at 19.
All right, Officer Cogdale, good afternoon, sir. Sir, if you please approach the witness stand. Once you get there, if you would turn and face Sergeant Brown, be sworn as a witness before you sit down, sir.
Do you swear affirm the testimony you're about to give is the truth, the whole truth, nothing but the truth? I'm seeking just to the microphone. State your first and last name.
So, first name is Curtis, C-U-R-T-I-S. Last name Cogdell, C-O-G-D-E-L-L.
And Officer Cogdale, where are you employed?
Atlanta Police Department,
And how long have you been in the Atlanta Police Department?
a little over 15 years.
And where are you currently assigned?
Zone 3.
Yes, there was a police report on the mall incident. It was sent to a prosecutor, and the prosecutor dismissed everything. It was not even worth their time to even investigate. Yeah, they were not even charges, just alleged incidents. It's a police report sent to a prosecutor who dismissed the case. Not even charged.
And where's the Zone 3 area?
South side of I-20, all the way down to South Central.
What's that?
Like one of Tahiti.
Okay. And how long have you been assigned to Zone 3?
A little, about 5 years.
And tell me a little bit about your work history within that.
My career, I started out in Zone 4 as a patrol officer, which is the west side of Atlanta. From there, I went to the Zone 15, and then from there to Apex K9 unit, and then to Zone 3.
And are you post certified?
I was.
And were you post certified since 2019?
I was.
Direct your attention specifically to September 25th, 2019. What unit were you assigned with?
What unit? Zone 3 patrol unit.
And just tell the jury a little bit about your job and your responsibilities as a patrol officer.
Patrol officer, you respond to 911 calls. You try to help reduce the crime by 5%, and traffic accidents, stuff like that.
And as a patrol officer in Zone 3, are you assigned to a certain beat or a certain area of
Yeah.
Zone 3?
Assigned to a beat.
Okay. And back in 2019, what beat were you assigned?
309.
And where is beat 309?
It is south of 166 all the way to Cleveland, right there by 75 if you're going east on Cleveland, or 85 if you're going west on Cleveland.
And is there a certain main roadway that sits within beat 309?
Say it again, sorry.
Is there a certain roadway, is there a major roadway that sits within beat 309?
It is. There's two. You have Metropolitan, and then you have Cleveland.
All right.
Parts of Cleveland.
Get our permission to approach.
Okay.
And I'm going to show, and I believe all the defense counsel may have, which is a copy of our exhibits. I'm going to show you what's the market state exhibit 28 and 29Q. Do you recognize exhibit 28 and 29Q?
I do.
And how do you recognize exhibit 28 and 29Q? 28 and 29Q.
That's part of my area that I patrol.
And is that a fair accurate depiction of a portion of the area that you patrol within Zone 3?
It is.
And is that a fair accurate depiction of the area that you patrol back in 2019?
It is.
Your Honor, this concept about the 10 exhibit 28 and 29Q.
Any objections to states 28, 29Q?
May I just approach Mrs. Miller?
Yeah.
For the most part.
Any objection?
No, Your Honor.
Hearing none, 28 and 29Q were admitted, and they policies you see fit.
Thank you, Your Honor. And Your Honor, of course, that screen is not on. I didn't, anyone from tech just says Zoom, but it's, sure, I apologize. The witness screen is not on, it just has Zoom, it doesn't have the images on the screen, so at a packet break, if you could.
There's a reason that one's been disabled, so you're gonna have to use the other one.
Okay.
Okay.
Thank you.
And he can get up and relocate himself if he'd like to, okay?
Okay, thank you for that. All right, if you can just orient the jury, and if you need to stand, you can, to what we are seeing as exhibit 28Q.
Say that again.
If you can orient the jury about the map location in 28Q.
Yeah, Metropolitan, we had the Cleveland area.
Okay, and on 28Q, where is Metropolitan?
It is, it runs north and south of Cleveland. There it says 41.
And when you say 41, this is what we're referencing?
Yes.
All right, and you just referenced Cleveland Avenue, this is what we're discussing?
Correct.
Okay, now where was your beat, or where is beat 309?
309 would be,
You can step down and move.
309 is Cleveland from 75 going westbound. So you would have Metropolitan.
Going this way?
Correct.
All right,
And it would stop right there at Springdale going north.
okay, so this area, this block
Yeah,
here,
up to 166.
up to 160, so this square is 309.
Correct.
All right, and back in 2019, that square was your general beat, or 309. Okay. Now, taking back to September 2019, did you have a certain shift in which you worked?
Yes,
What was your shift?
evening, which is 2 p.m. to 10 p.m.
And is that your current shift now?
It is.
Have you worked any other shift while in zone 3 outside of the evening?
No.
I'm going to direct your attention specifically to September 25th, 2019. Were you working that day?
I was.
And were you working the evening shift as you just testified?
Okay, we are on an incident in 2019. I wonder what pile of nothing this is.
I was.
And where were you? Were you on patrol?
I was.
And where were you on patrol?
That day I was posted up right there in Metropolitan and Peg Road.
And you said Metropolitan Peg right here?
Correct.
All right. And is there a business location at Metropolitan Peg?
It is. It's a storage facility.
All right. And coming southbound on Metropolitan, would the facility be on the right-hand side of the street or the left-hand side?
If you're coming south, it will be on the right.
All right. And were you Where were you within that facility?
I was sitting right there at the entrance of the parking lot to come into the storage.
And why were you sitting there?
They had several complaints about people breaking into the storage unit, so I was just patrolling that little area.
Okay, and as you were patrolling that area, what if anything happened?
I was over the today, traveling southbound on Metropolitan.
And what if anything did you notice when you saw the resident city of traveling southbound on Metropolitan?
Okay, I need to show you something else from Thugger Daily. Rumor unconfirmed. Multiple different sources close to the situation have been telling me that, or him, that Lil Woody, also known as Kenneth Copeland, was just shot. He is the guy whose 2-hour interrogation leaked of him snitching on Thug and YSL. Will update if I get more info and confirm, deconfirm. Woody responds to this rumor. Seems like it's probably false. All right. So nothing there. Okay. Now we know. Let's go back to the trial.
The driver dancing around in the driver's seat, and as he passed me, he wasn't wearing a seatbelt.
Okay, and let me ask you this, when you were sitting at the Q Smart, were you facing, was the front of the car facing Metropolitan?
It was facing in front of Metropolitan.
Okay. And do you recall what kind of red vehicle it was?
It was a red Nissan.
All right. And you said you saw the driver dance around this.
Correct.
Right. Did you see anyone else from your vantage point at that time inside the vehicle?
There was nobody else in the vehicle.
Okay. As you saw the individual dance around your vehicle, what did you think happened next?
Sadly.
Once you saw the driver dance around the vehicle, what did you think happened next?
So as soon as he passed me, I noticed that he wasn't wearing a seatbelt, so I immediately got out in traffic to get behind the vehicle.
Okay. And what happened once you got behind?
Once we approached the intersection of Metropolitan and Cleveland, I activated my emergency lights to get the driver to pull over.
And did the driver pull over?
He turned on his left signal to turn into the Dollar General parking lot.
And where is the Dollar General parking lot?
It sits on the corner, east corner of Metropolitan and Cleveland.
All right, look at that right here. Where is the general vicinity where the Dollar General will be?
It will be right up here.
Right here? Yes. Okay. And what happened once the vehicle turned into the Dollar General?
As soon as we entered the parking lot, we immediately continued to the other side of the parking lot, back out onto Cleveland.
I'm going to show you what's been marked as 6635Q, which should be picture 3. Can you recognize what's the 6635Q?
I do.
How do you recognize what's the 6635Q?
That's the Dollar General right there at the corner of Metropolitan and Cleveland.
Is that the same Dollar General that we just referenced on there?
It is.
And is that a fair and accurate depiction of the Dollar General back in 2019?
It is.
Your Honor, this something like 10 or 6635Q is that?
Ingestion states 35Q. States 35Q is admitted and maybe published as you see fit.
Okay. For the jury, this is Dollar General that we just been speaking of.
I guess I can spoil the fun for you. This traffic incident is not about any of the defendants. It's about a person who is allegedly in that gang. That's it. That's it. So we are up to an incident in 2019 involving a person who is not one of the defendants. It's a person allegedly connected to them.
Is that the Dollar General?
It is.
And if you can just orient the jury right now to what we're seeing, where's the intersection, and what we're seeing in 6635Q.
The intersection is right there where the red light is at, so that's the main street you're looking at, that's Metropolitan, and then where the red light is at, that's Cleveland. And then he enters the parking lot right there where the gentleman is walking across at the entrance of Metropolitan to the Dollar General.
And it's fair to say that gentleman wasn't there back in 2019?
No.
Okay, all right, so when he made the left into the parking lot, and you have to stand up, you can tell the jury, show the jury what direction he.
Yeah. Remember, this is day 12 of this trial. Now, roughly, on average, an actual trial, let's say it's a burglary, drugs, assault, and something in violent sexual nature. That's 4 cases a day, usually. trials normally doesn't take that long. The trials we watch here, it's because it's interesting from for Law and Seaward. It's interesting for Fox 4 Dallas. It's interesting because it takes a bit longer. But usually, four cases a day. This is day 12. That means it's 12 times 4. That's 48 cases that could have been run through this court, where a victim and a defendant could have had their day in court. But they're not, because Miss Fannie Willis is running for Attorney General later this year. And she wants big cases that get some publicity. And that's just this RICO trial. On the 8th of January, another RICO trial starts. It's about YFN whatevers, another rapper, another RICO trial. And on top of that, you have the RICO trial against former President Trump. So in Fulton County, the greater Atlanta area, 3 simultaneous RICO trials. That will take up 3 courtrooms, 4 months. Meanwhile, victims of robbery, victims of rape, victims of whatevers will not have their day in court. You have defendants who will not have their day in court to prove their innocence. Excuse my language. I know they are innocent unless proven guilty, but you know what I mean. Every day, 4 cases, for a lot of victims, a lot of defendants will not have their day in court because of this crap.
So we entered the parking lot. He immediately continued around the building to the other side of the parking lot, which is another entrance that leads up to Cleveland Avenue.
Okay. And did you go behind?
I did.
All right. And what happened once you get to the other side of the Dollar General?
Once we get to the other side, he immediately made a left onto Cleveland, and then we were traveling eastbound on Cleveland towards 75.
And let me ask you, back in 2019, driving southbound, was there any traffic driving southbound back on this date, September 2019?
It was. It was a matter of fact, the light was red, so it was picture perfect. There was cars there, so we had to turn into the Jolly General.
Okay. And was there any traffic going northbound or Metropolitan?
No.
All right. So once he goes left onto Metropolitan, what if anything? I mean, excuse me, left onto Cleveland. What if anything?
Once on Cleveland, the vehicle started picking up speed and continued towards 75.
When the car began picking up speed, what if anything did you do?
That was radio that I had one refusing to stop. Let her copy my traffic, and I proceeded to follow the vehicle.
Okay. And what if anything occurred if you see the car?
I noticed the vehicle went around traffic into the center lane, and right there it says Cleveland and Forest Hill. He ran the right.
What happened? You just point to
29 Q.
All right, I'll show you 29 feet. Okay, so you said that he was going around traffic.
Correct.
Show the jury area he was going around.
You got Forest Hill right there in Cleveland. There's a traffic light right there. And then the light was red and you went around traffic and ran the traffic light.
Okay. So right here at Forest Hill in Cleveland, there's a traffic light at Cleveland?
Mm-hmm.
Remember that, yes?
Yes.
Okay, and you said, did the car run that light?
Correct.
All right, and what happened once the car ran the light?
He crossing over 75, still on Cleveland. At this time, I'm approaching Forest Hills at the light. Once I get through the light, I noticed that he was in a vehicle accident.
Okay, and at this one, do you know
Yeah.
how fast y'all were going?
We are now in a police chase over no
Probably
seat.
around 45, 40, can't percent how fast he was going. Because he had a little bit distance ahead of him.
Okay, and once the accident occurred, what happened?
I noticed that he was already out of the vehicle and then he was running on foot.
And when he ran on foot, I'm probably gonna do exercise today.
Okay.
Where did he go?
There's a cash on place and a cleaners right there at that corner, which there's a fence blocking to keep traffic from running into the buildings and stuff. So he hopped that, scared the fence, jumped over the fence, and then started running through the parking lot.
Okay. And when you said the check cashing place and the dry cleaners, where approximately on this map is the check cashing place and
It's
dry
going to be
cleaners?
that first small square buildings.
Right in this little block up here?
Yes.
Okay.
And then the cleaner's going to be the little L shape.
All right. So the first small block is the check cashing place. The L shape is the cleaners.
Correct.
There's another gray box. What is that?
That is the admission place.
The admission place. Okay. What direction did he run?
He's running kind of south in between the check cashing place and the cleaners. And then he runs behind the cleaners.
We started here, we ended over here. We took these routes instead of back, forth, back, forth, back, forth. This is just extending the torture. Here is later on in the police chase. They are playing the actual footage.
And right here, this is you sitting in your vehicle at the Q Smart.
Yes, yes.
Interesting chase, right? Body cam, not police car cam. Over a seatbelt. Must have been a slow day that day.
230 Cleveland, 230 Cleveland. 230 Cleveland. Black male, black shirt, black jeans. Black male, black shirt, black jeans. 10 to the 44, 10 to the 44. Get down, get down. 10 to the 44. Running towards the apartments. Running towards the apartment. Back here, so look. I received 3309. Just one person or
10 seconds. We'll stop within the video. Say the number you use. 5 minutes and 10 seconds. There were a few things that were shouted.
Yes. Seatbelt chase. Oh, Crime Spice raid. Thank you. Thank you, Crime Spice. Oh. Yeah. Welcome to the welcome from Crime Spice. This is the Georgia Rico trial against young thug Jeffrey Williams and the supposed YSL gang. This is day 12, and so far we have for 12 days listened to testimony about alleged crimes the defendants were never charged for. Because it's a Georgia Rico case where they hide this little fact that nobody was convicted of these crimes as underlying acts in the Georgia Rico Act under the Rico charge. So in the Georgia Rico Act, you can charge people as a criminal enterprise where the understanding of the criminal enterprise can be spoken or unspoken. That's in the actual Georgia RICO Act. Spoken or unspoken cooperation in to further a criminal conspiracy. Sounds sweet, right? Hi, Toddly Pip. What happened to the person who was attacked in prison? He is back amongst the defendants. He was stabbed once in the stomach, once in the back. So they stitched him up, let him rest, and here we go again on day 12. What we've just been seeing is a police chase for several minutes. Because the cop saw inside the car that the driver wasn't wearing a seatbelt. Now, then he chased after the car. The guy abandoned the car and started running, and he's gone. He outran the cop. And that's where we are right now.
In the video. One, what's a 41?
Accident.
Accident?
Mhm.
Okay. And then what's a 44?
It's a robbery.
And in looking, first, what we have depicted on the screen right here, that's apartment six.
Mhm.
So we're gonna use that.
Okay.
What are we looking at here? Is this an apartment complex?
Yeah, this apartment this is the backside, or you saw when you walked through the cover. This is 2612 Still Avenue.
And on the other side of 2612 Still, I'm gonna fast forward slightly to about 6 minutes, maybe about 7 minutes. If I want you to tell me what we're seeing a little bit past 2612 Still. So stop, pausing right here. What area, what are we looking at? If you go straight,
If you go straight up to the steps, there's a fence right here, and then on the other side of the fence is another apartment complex.
and is there a way to get from 2612 Still to that other apartment complex if you were going to?
Yeah, if you were to run behind this building right here, further up, there's a makeshift cut or path.
Now, the guy they chased is gone. So now they are talking about what apartment complex can you reach from that apartment complex. So, yeah. And that's about it. Now, here's what they found in the car. So that's a bit, yeah, that's bad. That's really bad. Hey, Hella, how are you doing? So, the man driving without seatbelt got chased, went out of the car, ran, disappeared, but in the car was this. So, yeah, good hunch from the police detective. Here's the thing. This that you see here is not connected to any of the defendant in this RICO trial. It's connected to a person who the prosecution alleges is connected to the defendants. Isn't that swell? And then there was a break. And they replayed this guy's testimony a few times. And they played some more. And they played some more. And they played some more while they waited for the trial to restart. And here's the cross-examination, I believe, of that officer.
Hold on. Can I get you to step outside for just a second, please?
Yes, and now they are asking the witness to step out for a while because they are having a hearing. This is more of a recap of today because All in all, in 7 hours and 45 minutes, it was roughly 3 hours of testimony. All about, in my opinion, yeah. I mean, I kind of agree with Shafos here. It seems like Georgia prosecutors and Georgia police, if they can't find enough evidence to charge people individually, they will use the RICO Act and the extreme vague language in it. As I said, the language in it for the prosecution to prove a criminal conspiracy or that individuals are forming a criminal enterprise is that the agreement can be spoken and unspoken. I'm not joking. And as we realized here, if Georgia wanted, because Georgia can go outside of jurisdiction for the RICO charge. So if they wanted, they could they could name all of us in some made up bull crap. And say we are a criminal enterprise. More or less. That is the definition of a police state, in my opinion.
The state during the race has indicated you can show me some what your decertified convictions, but my client had indicated that I don't know if it's going to be later today or tomorrow, it's sometime in the future.
Wait. Can you all go back, please? Thank you. Okay, so you said he certified convictions?
Right, that they're going to seek to introduce into evidence. And
Okay, and they have shown this to you?
they have, and there's
Okay.
4. Two of them, I believe, relate to overt acts or alleged overt acts in this indictment. My issue, other than some extraneous pages included in the certifieds, my issue is not with the admission of those subject to our prior kind of blanket Bruce Harvey rule objections. However, 2 additional convictions, there's one from 2010 and I believe 2011, are not listed as overt acts in the indictment. The state's stance, I believe.
Okay, so this is not about cross-examination. This is something the defense have found in the prosecution's manuscript over this trial.
Is that they are listed in the overt act itself, overt act 98. If you look at it, my client is alleged to have committed possession of firearm by a convicted felon, and in the state, in the pleading, lists 4 separate felonies that they're alleging my client, that make my client a convicted felon. Those
That doesn't make sense. I mean,
that does, because you only need one.
you only one, okay, but.
Right, and so they've listed 4, and now they're seeking to introduce certified of 4 separate extraneous convictions that, again, I'm acknowledging that 2 of them are overt acts in this case, and that's not my.
You don't have the objection to those?
There's some extra paperwork in there that I can specify what I object
Okay,
to.
well,
but-
you know that when, let's assume that I admit them, okay, if they're in
Yep.
proper form. Before they go to a jury,
I
there's
understand.
some of the things that will be stripped out because they would violate the continuing witness rule and some other things.
I understand. And
So we'll get to that
Right.
later, but,
But I do object to the 2 that are not listed as overt acts
okay,
because
the ones in
it violates.
2010 and 2011?
I don't have them in front of me. The state has them. I believe I know one of them is 2010. One's a burglary, and then one is a theft and a gang charge, ironically charging a separate gang, but those should not be admitted into evidence. And I'm relying on Old Chief United States 519.
Old Chief?
Yes.
Oh. You
519.
found anything more recent?
US v. Marroquin, Marro. US v. Marroquin, Marroquin Lopez, 634 Federal Appendix 758, that's 2015, but it discusses O'Chief. O'Chief's still good law, and it basically, Judge, it
I
just comes,
understand.
it comes down to 403. I mean, I don't think anyone that's been watching this trial, anyone that heard my opening would suggest that that the issue of whether Mr. Stillwell is a convicted felon is really at issue. It's not at issue. It never has been an issue. I said in opening.
They still got to prove it. They still got to prove it.
And they can with a prior, but they don't need to prove it with 4. And the prejudicial value substantially outweighs the probative value when things do not have probative value. And so if you look at the indictment Act 98, they list 4 prior felonies: participation in criminal street gang activity from May 2010, which is indictment 11 SC 98860. I object to that. They list a burglary from June 2nd of 2011, indictment 13 SC 121320. I object to that. Then they also list possession of marijuana with intent to distribute from September 19th, 2013, which is 15 SC 140132. We've heard testimony about that. And my client pled guilty to that, and we understand that that is listed as an overt act. So we're not going to specifically complain about the admission of that one. And the other one is possession of marijuana with intent to distribute, possession of firearm by a convicted felon from March 10th, 2016, which is 15 SC 140132, and I don't object to that. The other one I don't object to, I'm sorry, I read it wrong, Your Honor, it's 13 SC 121320. The ones I object to are 11 SC 98860 and 10 SC 87662.
Okay, well, they pled them specifically in the act, and that's Act 98, right?
Correct.
Okay, so, I mean, if they're in proper form, when they go to an element, I mean, they go to an element of proof.
No, we could easily redact this indictment. We did it with count 25, I believe it was, on this indictment.
That's for another ground now.
Well, it is, but I mean, it can be done. And the bottom line is, all of this still needs to pass Rule 403. Just because the state puts it on a piece of paper doesn't mean 403 doesn't apply.
I understand. Okay. Well, and if I understand your objection, are you saying that it's, are you saying that it doesn't, the court needs to apply the 403 balancing test? I mean.
Yeah, as discussed in the Old Chief case and the other case that I cited, and many other cases, Your Honor. And also, I'll just point out the prejudicial value. The prejudicial value of these priors that are not listed as overt acts, specifically 10 SC 87662, is particularly great based on the charge being participation in criminal street gang.
All right. What's the state's position on that?
Dave, thank you so much. I miss you too. Are you trying to speak to text to your wife and accidentally did speak to text to this stream? Oh, by the way, Dave, while you are over in America, I'm meeting your wife on Saturday. Just saying. Let's continue to listen to state's position on them wanting to remove 2 of the 4 overt acts as unnecessary and more prejudicial than probative.
Your Honor, the state's position.
Can I see the convictions to begin with? Do you have them? You have them?
Yes.
Okay.
And just for clarity, for the purposes of the record, Judge, you have labeled State's Exhibit 31Q.
Hold on a second.
Dave doesn't need a link. He has access to my StreamYard.
Said 31Q, and which one's this one now?
This is the certified for 10SC 87662, Your Honor.
Look at Dave backpedaling. Oh, look at Dave backpedaling. Now he's blaming... I was supposed to they missed so much of the trial. Yeah. Yeah. Oh. Oh. Let's continue listening to the prosecution.
Which is a part of the allegation in not only count 98, but count 55 as well, as we discussed with Mr. Sharp prior to speaking with the court.
Okay, what's the next one?
The next one is 32Q, which is the certified conviction for 11 SC 98860, which 2 is listed in both Acts 55 and Acts 98.
Okay,
We then have states 33Q, which is a certified conviction for 13 SC 121320,
so 13 SC, what was that, I'm sorry?
121320.
121130?
No, Your Honor.
I'm sorry.
13 SC 121320.
Thank you.
You're welcome.
And what does that go to, counts what?
And that too is listed in Acts 55 and Acts 98.
Okay,
And we also intend to introduce states 30Q, which is the certified conviction for 19 SC 173371, which is the act itself that is alleged in Act 98. Part of the act. And I will present them at the court's pleasure whenever the court tells me to present them, the court can present.
okay, have you seen them, Mr. Sharp?
I have.
Can you
Yes.
approach, let me look, hand it to Mr. Kearns, please, so I can.
Oh, and the
And I can
Stipulate to.
Oh. Yeah, I have a sidebar counter. In total, on 12 days of trial, we are up to 42 sidebars. 42 sidebars. Why? Because the prosecution is trying to sneak in stuff and the defense wants stuff out. That's more or less it. Let's continue. Okay, let's hear.
What are you doing inside bed? I want to see you. Hey, come on, man. Time just one second, okay? All right, go ahead. As soon as he finishes.
John, I was gonna add 2 other things. I just wanted to call your attention to the fact that both of these convictions that I'm arguing against are alleged to have occurred prior to the alleged RICO conspiracy. But also, most importantly, Your Honor, we shouldn't have to because we've basically done it in opening, but we're willing to stipulate to my client's convicted felon status if that clears anything up. I mean, I don't think, again, from watching this case, I don't think that's an issue at all. And they have at least two prior felonies that seem to make that pretty clear. And we're not arguing that it's not clear, but we'll stipulate to it, in fact. But we just don't think it's appropriate just because the state throws things, the indictment to bring in bad character evidence against my client.
I don't think it's bad character. It's, and they're not doing it for that particular reason.
Well, what is, I mean, I just don't understand what the reason is, because the only legitimate reason is to prove he's a convicted felon, and he clearly is. So.
Well, I'll let the state respond to that. Is that the two bases?
Yeah, we're willing to stipulate.
Okay, all right. Yes, Ms. Lowe.
Thank you, Judge. Your Honor, what it seems that Mr. Sharp is doing is asking for essentially a striking of the indictment, something that should have been dealt with pre-trial, because where we are now in Act 55 and Act 98, these are portions of the act that the state alleges, so they constitute proof of what we've alleged in the indictment. As to the argument regarding 403 and a 403 analysis, these allegations are not allegations that, or the certified convictions rather, are not convictions for the types of crimes that are substantially more prejudicial than probative as they relate to Mr. Sharp's client. The fact that he now asserts that these crimes happened prior to the beginning of the alleged conspiracy is of no consequence, especially where it's these acts that have occurred are in fact kind of integral to other evidence that will be presented at trial. Mr. Stillwell, in that 10 SC 87662, committed those acts as part of the criminal street gang that we do reference in this indictment. We talk about 30D, we talk about not just YSL. Mr. Stillwell, in one of the songs or lyrics that may be talked about, there's a reference to the Blue Jean Bandits, there's a reference to 30D, and this is just ancillary, but this gang charge that is alleged in 10 SC 87662 is in fact one of those kind of incidents where she's alleged to have and actually was convicted of gang activity for that type of act on his part, along with others. But that aside,
each month, thank you, Excited, for being a member for 7 months. And YouTube is giving me the opportunity to gift 10 memberships each month. I gave 5 yesterday, and I'm gifting 5 today. And Heather Mosher, C. Sauder, Papa G. Gross, Unbreaded Beer Chicken, and Peggy Sheridan was gifted memberships. Congratulations! You now have access to all of my members-only content. You also can go to my community page. There will be a link for members only to my Discord. Hey! And thank you, Hella, for being a member for 7 months. I saw that I was muted. Yeah. Yeah, Dave, it's so similar to the Whitmer kidnapping case. Let's talk about all these other people and all the bad stuff they do, and then somehow try to tie it into these defendants by implication. Let's continue.
Your Honor, the bare fact is that the state has alleged in Act 55 and Act 98 that Mr. Stillwell had been convicted of these offenses, and the state has the right to prove up its indictment in the way that the state sees fit. This is not one of those circumstances where the convictions in any way prejudice Mr. Stillwell, and certainly they don't substantially prejudice him in a way that makes the admission of these convictions more prejudicial, substantially more prejudicial than probative. He's essentially trying to dictate the way the state proves up its case, and the defendant doesn't have the right to do that. The state has the right to prove up its case in the most effective and impactful way that we are legally allowed to do. And given that we have made these allegations that this indictment has been read to the jury, and that we have bona fide certified copies of these convictions, the state should be allowed to introduce that evidence to the jury, and should not be kept from doing so for reasons that are not, there's no reason to keep the state from doing so. The defendant just does not get to dictate how the state proves up its case. So we are just asking that the court deny these motions to keep out evidence of acts that have been alleged in our indictment.
Your Honor, they keep saying I don't get to dictate how they try their case, and I acknowledge generally that's true, but that's the whole holding of Old Chief is just because they allege it in the indictment doesn't mean they get to just let everything in, no matter how prejudicial it is, no matter how limited the probative value is. That's the whole point of Old Chief.
Old Chief is a little different. Old Chief, this is Old Chief versus US, 519 US 172, a little different aspect. I see what you're saying about Old Chief in terms of you're willing to stipulate that particular issue in terms of the convicted felon issue, which Old Chief was a singular issue, and that's part of why the Supreme Court dealt with it in the manner that they did. The state is alleging, however, that given the other elements of proof that they are alleging, in particular acts 55 and 98, 55 being the defendant from the incident involving 7/15/2015, defendant Shannon Stillwell, associate Weisel, did commit the felony offense of possession of a firearm by convicted felon in violation of Georgia law pursuant to LCGA 1611-131 by possessing a firearm, to wit, a handgun, after being convicted of felony in indictment 10 SC 87662 in the Superior Court of Fulton County for the offense of participation in criminal street gang activity and burglary on the 26th day of May 2010, and indictment 11 SC 98860 in the Superior Court of Fulton County for the offense of burglary on the second day of June 2011, and indictment 13 SC 121320 in the Superior Court of Fulton County, Georgia, for the offense of possession of marijuana with the intent to distribute on the 19th day of September 2013, an overt act in furtherance of conspiracy. So, and then, in addition, in Act 98, they allege similarly participation in criminal street gang activity and these acts in furtherance of overt acts and furtherance of conspiracy. I know it may. In looking at it from a 403 perspective, Mr. Sharp, and of course, in looking at Old Chief and looking at what the measure of prejudice is, evidence is unfairly prejudicial when it would influence a jury to decide the case on an improper basis, and courts have noted that there's a difference between evidence that is simply prejudicial and in that it hurts a party's case admissible, and evidence that's unfairly prejudicial, which is inadmissible. So, the 11th Circuit, in looking at this particular issue in the United States versus Patrick, that's 513 F APPX 882, 11th Circuit 2013. Now,
what's going on in this is that the defense lawyer is protecting this for appeal. He brings it in so he can bring it up in an appeal. My assumption is he already knows he's going to lose, but he brings this forward for appeal. That's it. But sometimes it works, but mostly it's for appellate issues. So,
invoking the exclusionary elements of 403 evidence and prejudicial, but unduly. So, in this particular circumstance, I don't believe that these particular convictions. Now, there are some things in there that will need to be discussed and paired out before actually being handed to a jury. But I don't believe that this is going to lead to confusion of the issues, mislead the jury, be a waste of time, unduly delay, or needlessly present cumulative evidence. So, applying a 403 analysis.
Unduly delay. Remember, when the state said they were ready for trial in November of 2022, they had 79 witnesses. A year later, December of 2023, once they actually got to trial, the prosecution had 737 witnesses. The case grew 10 times from when the prosecution said they were ready for trial. And this judge allowed it all. Is the prosecution saying that because his client was a convicted felon with a firearm and punished for that, he is therefore part of the gang? These are underlying acts, overt acts. Hey, Dave, welcome.
Hey, you know what? I said I was listening to you, and I thought, you know what? I'm going to figure out a way to jump into your stream because I've never been able to figure that out. But now I know.
Yeah, you
Very
have access to my StreamYard.
well. Yeah, but I could never like find somebody's account, and now I found everybody's account. So now I know how to get on Valhalla's, and I know how to get on Legally Lives. I'm going to do a stream on Valhalla's channel later, guys. Check it out.
Yeah,
but
do you know? Do you know this old chief case they are referring to?
What's the case now?
Old chief v USA about prejudicial versus probative.
I don't know the specific case.
It's
Give me a citation. I can pull it up. I mean, I'm not good at names in general, so if you give me a case name,
it says Old Chief v USA. That's what he called it, the judge.
Okay, let me like OLD for United States. Okay, here we go. Got it. Supreme Court case, U.S. Supreme Court case, and let's see. Subject to certain limitations, the particular statute prohibits possession. Oh no, wait, hang on. So this is about what's the issue?
One of against Mr. Stillwell, I guess. He has 4 prior convictions. And in the underlying acts, there's just 2 of them. But now, apparently, the prosecution has added all 4 of them to prove the point that somewhere along the line, they will prove he had a gun while being a felon.
Okay.
And then the defense are arguing they don't need all 4 for that.
Yeah, and so here's a head note from that case. It says if relevant evidence is inadmissible in the presence of other evidence related to it, its exclusion must not be on the grounds that the other evidence has rendered it irrelevant, but on its character as unfairly prejudicial, cumulative, or like its relevance notwithstanding. So you only need 1 prior felony charge to prove that this guy was a felon in possession of a firearm. So you don't need all 4. It would be unfairly prejudicial. It would be cumulative. It would be whatever. And then it goes on to cite this is a particular federal rule, and this is in state court, so it might be a little bit different with regard to that. But essentially, the exclusion of relevant evidence when its probative value is substantially outweighed by the danger of unfair prejudice is essentially up for the jury or the judge to decide.
Yeah, it's up to the judge. And the judge is now citing a case from 2013 in an 11th Circuit Court case.
11th Circuit would be the court that would be over Georgia, I believe. This is a 1997 U.S. Supreme Court case.
Yeah.
Hello, all in chat.
Hello, everybody in chat. Yeah. Yeah, so of course he will allow it because one of the reasons in this was to not delay a trial. But here's the thing. As I said, November 2022, the prosecution says we are ready for trial. They had 79 witnesses. December 2023, when the trial started, they had 737 witnesses. And the judge has allowed it all.
Well, some of the witnesses are going to die before this trial even gets to them. You know, like that last witness, or the one I saw earlier, that when they had the stroke, you know, they want to like get him out of the way because 9 months later he might be gone.
Yeah, and so, and I told the audience most of this is for the defense to protect it for appeal.
I would be curious. I would be really now. If I was a judge, I would say no. You only need 1 to prove that he's a felon, and I would actually argue that I can just take judicial notice that he's a felon. And I would argue essentially as a defense judge, we'll stipulate that he's a felon, take it out of the jury's hands.
Yeah, but let's go back a bit where he reads his case, which he probably will rely on for allowing 4 felony convictions to prove he owned a gun as a felon.
Okay.
and these acts in furtherance of overt acts and furtherance of conspiracy. I know it may, in looking at it from a 403 perspective, Mr. Sharp, and of course, in looking at Old Chief and looking at what the measure of prejudice is, evidence is unfairly prejudicial when it would influence a jury to decide the case on an improper basis, and courts have noted that there's a difference between evidence that is simply prejudicial and in that it hurts a party's case admissible, and evidence that's unfairly prejudicial, which is inadmissible.
All evidence
So,
is usually
the 11th Circuit, in looking
prejudicial.
at this particular issue, in the United States versus Patrick, that's 513 F APPX 882, 11th Circuit, 2013.
Want me to repeat that?
Yeah, what was that citation again?
So the 11th Circuit, in looking at this particular issue, in the United States versus Patrick, that's 513 F APPX 882, 11th Circuit, 2013.
US v. Patrick.
2013.
USP Patrick 2013. That citation doesn't make sense. He's citing to an appendix in the case itself, which is really weird. Okay, it's 11th Circuit. Let me go to 11th Circuit. 11th Circuit. Oh, there's only 31,000 cases. USP Patrick. Here it is. Oh, shoot. Oh, well, all right. I just paid the $24. Okay. It's like, oh, it's $24, and then my finger just automatically went to it. All right. Under the doctrine of, all right, what's he going to say now? All right, I have the case pulled up. Let me hear what he says about it.
While invoking the exclusionary elements of 403, in addition to cautioning that the rules should be used sparingly, the 11th Circuit Court of Appeals looks at the evidence in light most favorable to its admission, maximizing its probative value and minimizing its undue prejudicial impact. Consistent with this authority, courts have noted that the key term in 403 is not prejudicial, but unduly. So in this particular circumstance, I don't believe that these particular convictions, now there are some things in there that will need to be discussed and paired out before actually being handed to a jury. But I don't believe that this is going to lead to confusion of the issues, mislead the jury, be a waste of time, unduly delay, or needlessly present cumulative evidence. So,
wait, okay, so he just said, towards its admission, right?
Yeah. Let's go back.
Accordingly, Rule 403 requires courts to look at the evidence in the light most favorable to its admission, maximizing its probative value and minimizing its undue prejudice. Where was that citation from? So it cites Old Chief, and then it cites a Fifth Circuit court, but that's not what that said. It cites it's basically, so the 11th Circuit has created this rule and just citing itself. That's what it is. So the 11th Circuit is citing itself going back to 1989. So 1989, then a 2006 case are being cited over the Old Chief U.S. Supreme Court 1997 case.
So they are nullifying the Old Chief.
Yeah, basically, they're creating an exception to the Old Chief rule, relying on a 1989 case in the 11th Circuit. That's what.
But the Old Chief case is from 1998 and should be nullifying the 1989 case. So why are they citing the 1989 case? That's already gone. It should be, at least.
Well, it should be, but there's like they'll say like, well, yes, that's what Old Chief is saying, but there's this other rule out there, and Old Chief didn't really say that this other rule doesn't apply as far as like the rule being how do we weigh everything? We weigh it in favor of admitting it. Like Old Chief didn't really touch on that, so we can get around it by citing to this 1989 case and a 1979 case. And yeah, so that's what they did. And it's all inside the 11th Circuit.
So it's a circular argument to justify keeping pre-Old Chief rules.
Yeah, and so Excomer says, how can they do that? Well, so when the Supreme Court hands down, I'm not reading these cases like side by side, but let's assume Old Chief was talking about something very specific. What are they talking about? And let's say the Supreme Court rules on that. And then the 11th Circuit could say, okay, we're taking a look at Old Chief, but Old Chief didn't touch on this very limited particular issue. And since we have an older case that already dealt with that, we're going to go with the older case until the Supreme Court says, no, this also applies to that very specific issue.
Yeah.
That's kind of how they get around it.
Yeah, and that's what he said earlier also, that Old Chief was very specific, and this, more or less, this is a RICO trial. And since Georgia RICO has never been challenged on a federal level, yeah.
Yeah. See, Old Chief talks about what unfairly prejudiced means, what it looks like, what it looked like in that particular case, but it doesn't talk about necessarily how the court would not weigh or lean at the beginning. Like, are we doing a de novo review, which is from the scratch? Are we like a summary disposition motion or a motion for a directed verdict? Has to take a look at the evidence and most favorable to the state and see, even in that situation, the state cannot sustain its burden, so we must dismiss. Old Chief doesn't really talk about that. So they're relying on this older case.
Okay. But here they are proving possession of a firearm while felon with 4 convictions.
See, if that older case said you should minimize the prejudicial, the aggressively prejudicial. Okay, let's start off with this. All evidence, ideally, all evidence presented against a party is prejudicial to that party, right?
Yeah.
So it's all prejudicial. The question is it so excessively prejudicial?
Yeah.
And if the court had said, which my reading of these two cases very briefly, just going through the head notes, doesn't seem to indicate, if there's a way to admit the evidence without having the unduly prejudicial effect, then you must, which I believe is what this Michigan's rule is. This doesn't say that. So, and it's up to the judge's discretion.
Yeah, it's always up to the judge's discretion. And this judge, it's
whatever it takes to justify it, like Shawfoss says.
Yeah, whatever it takes. Okay, let's keep listening.
The 11th Circuit Court of Appeals looks at the evidence in light most favorable to its admission, maximizing its probative value and minimizing its undue prejudicial impact. Consistent with this authority, courts have noted that the key term in 403 is not prejudicial, but unduly. So,
and I would say additional 3 felonies is unduly.
What's up?
I would say that adding 3 additional felonies is unduly because it's not actually necessary.
It's not necessary to prove he had a gun while a convicted felon. They only need one of them.
Yeah. See, this is why, as a defense counsel, I would almost stipulate and ask the court to take judicial notice and be done with this in front of the jury anyway.
Yeah, I think that was what the defense lawyers were trying. But what the judge said earlier is, this is not a now moment, but he will address it before he hands it to the jury.
These freaking judges that are unwilling to make decisions.
Yeah. Yeah, I know. Here's the thing. This judge has said, we will address it when we come to it. And then when they come to it, and then when you come to it, why didn't you bring this up earlier? We could have saved some time. Well, because you told us, you judge.
You fine, handsome sir, you.
I don't believe that these particular convictions. Now, there are some things in there that will need to be discussed and paired out before actually being handed to a jury. But I don't believe that this is going to lead to confusion of the issues, mislead the jury, be a waste of time, unduly delay, or needlessly present cumulative evidence.
Of course, it's not unduly delayed when you already had made a 4 to 6 month trial to a year-long trial. Of course, nothing at this point will be unduly delayed or a waste of time. Nothing. You already made this a 1 year long trial while allowing the prosecutions to go from 79 witnesses to 737.
Yep.
So it's moving the goalpost in order to move the goalpost in order to move the goalpost.
Yep.
Instead of
You saw the same thing with the Alec Murdaugh judge.
yeah,
We'll come to it later. Or you see it sometimes with Shorter too, if you watch some of his cases. We'll deal with it when we get to it. We're here. Let's deal with it.
yeah. For me, it's every time. Okay, we can move the goalpost. Boom, on that separate issue. Next issue. Now the goalposts are back to where they were. No, instead the prosecution. Well, you moved the goalpost, so let's move. It's just a small, tiny, tiny little step. I'll allow it. And all of a sudden, the goalpost is moved again. And then the next issue comes. Instead of bringing the goalpost back together for every separate issue, no, now it's. I mean, you turn it from a hockey goal to a rugby goal, a goal line instead of a actual. Yeah.
Mm-hmm.
So applying a 403 analysis, I believe these convictions, if in proper form, would be admissible to prove the state's
I would minimize
case,
this so much
to
as a
prove
defense
that-
counsel.
or attempt to prove, I should say, because that's a jury's issue, whether or not they proven to a satisfactory extent.
That's the chief judge in Fulton County.
Yeah, but just because you're chief doesn't mean you know more.
No, and he's been a judge in the military, and he has been in Afghanistan helping them to create their judicial system. That worked fine, didn't it, Dave? Have you heard how great Afghanistan is nowadays? Yeah.
Acts 55 and 98.
Well, Your Honor, just briefly, if I can respond, to prove it is cumulative.
We're gonna disagree about that. Okay.
Well, if it's just to prove his convicted felon status.
No, they're going to prove whether or not.
Why is the judge saying what the prosecution will and will not do? He has done this so many times during this trial. He's telling the defense this is what the prosecution is going to prove. That's not your job, Judge. Shut the F up. Whatever I'm saying, it does not apply to Dave, who is a lawyer in the United States,
Well, I'm not
in
saying
Michigan.
anything.
No, but just so it doesn't reflect to you too much.
As listed in the indictment, whether or not they're acts in furtherance of the conspiracy. So a jury's free to believe it's just because they introduce them doesn't believe that they have to view them as proof positive.
They haven't, but there's different evidentiary means for them to get.
But they get to choose that.
But
You and I
they haven't
don't.
filed the pretrial motions to, like 404B. They would have to file a 404B.
They're not required to do 404B. It's not mimic evidence. Okay.
On a burglary from 2011.
It's going to what they allege in the indictment. So they have to be able to show that.
So
prove
it's
it.
going strictly to his status as a convicted felon, because that's the only thing that they've alleged.
Well, it's part of the elements in terms of, because one, you guys show whether or not he's a convicted felon or not. So yes, that goes to one aspect of it, but it's not, as an old chief, it's not the sole aspect of it. They've got multiple reasons as to why they're seeking that particular evidence.
Why is the judge arguing for the prosecution? Why doesn't he let the prosecution do the arguing, and then you make a ruling. Instead, you are there as the extended hand of the prosecution telling the defense, this is what the prosecution will do. It's inappropriate, in my opinion.
So,
And Your Honor, all I'm
so
saying is.
if it was just that, then I would more agree with your particular assessment that the 403 balancing test would tip. In this particular circumstance, it goes to more than that.
But they haven't provided the pretrial notice to use it via other evidentiary means or vehicles. So in other words,
No
they can
pretrial
say,
notice?
oh, well, it proves.
What?
They have no pretrial notice that they intend to introduce this. I doubt that very much since they're charging them. But I don't know. Okay.
Mr. Shannon Stillwell has a propensity to do this, or whatever their argument is.
But they wouldn't be able to argue that. That would be
Okay.
error for them to argue that.
Well, let's just say that it proves his gang membership. Just, that's an example. They would have to file,
as in the indictment.
and they would have to file a 418 notice.
We talked about this before.
And those aren't listed on it. That's what I'm saying.
This isn't other acts evidence.
Well, then what is it? It's just proof of conviction.
It's overt acts and furtherance of the conspiracy.
They're not listed as overt acts.
No, it's not.
On the indictment.
It's other acts.
That's
It's definitely other acts.
Mm.
I mean, at least in Michigan it would be.
Yeah, but why is the judge arguing what the prosecution should argue?
Because he's not certain in his position.
Yeah.
That's my thought. He's not certain in his position, so he wants to argue back to convince the defense that he's got to have a losing battle, so don't even file anything more. Don't even argue anymore. Just be done with it.
how the indictment's read. I read the indictment.
I'm not disputing that they can get into overt act 98. All I'm
Or
saying
55.
I'm not disputing that at all. All I'm saying is they can't bring in certified convictions after certified conviction after certified conviction as an element of that act.
It's only one element of whether or not he's a convicted felon.
They only need one conviction.
But that just goes to show. But it's more than that. They're going to show one. I mean, and look. You've asked. You're having discourse with the court.
Yeah.
So I'm just saying that it also goes to show whether or not they committed, or your client, whether or not they can prove your client committed any of these acts in furtherance of the conspiracy. Now, they may be able to show he's a convicted felon, but if the jury doesn't believe the other stuff, then that's only one thing. Now, whether or not he can be convicted of something else is another thing. But it is part of their proof in this case. I think it goes to multiple reasons. But State, you have anything else you want to add?
Yes, Your Honor, a couple of things. One, the state does not have to allege every overt act. And two, these are also intrinsic acts, and they don't have to be provided as pre-trial notice of intrinsic acts. These are all part and parcel of alleged conspiracy.
Intrinsic acts.
See, okay, all right. So here's the thing. I've got a guy that's being charged with a second offense, right? So whatever the crime is, it's a second offense. I've gotten notice that he's being charged as a repeat offender, as a second offense. Now, I don't need a crystal ball and I don't need a notice from the prosecutor to know that they're going to try to introduce it. So I am bringing a motion to exclude it, to prevent them from introducing it in front of the trial. And I'll stipulate to the fact, this is all stuff like it's kind of a BS argument from the defense, but it's also a BS argument from the judge. Unfortunately, I have to say the judge's argument is BS and not the prosecutor's. But everyone's just a little bit wrong, and they're going to admit it. That's kind of my takeaway.
Yeah. Well, he hasn't. I can't remember one single thing. Well, no, I actually can't. Remember, he always pushes things forward. And then he gets mad because they didn't bring it up earlier.
Didn't he show up like 50 minutes late or something today?
43 minutes late.
Okay, that was close. Can't delay this trial.
We have charged the defendants with in count one. So this argument about 404B fails. The argument about pretrial notice fails. And This is.
I still have to apply 403 though.
Oh, I didn't argue about
All right,
403.
okay,
And
okay.
I
all
just
right.
don't see how these are at all intrinsic to when they occurred before any RICO conspiracies alleged to have begun.
Yeah, here's the thing. The charges they want to bring in, because they go back to 2013 up to 2021. The two convictions are from he wants excluded are from 2010 and 2011. One of them was an additional gang charge for another gang.
Oh, now I see why. Now I see why the state's fighting so hard to keep it, and why the judge might be considering it other than other acts evidence. Because if this guy has gang affiliation, he has sort of a history of it. It's like an MO. Like think of Home Alone, right? Remember the burglars? They always turn the sink on and flood the houses after they leave. Well, that's sort of an MO. That's a modus operandi. And if they can introduce that sort of thing to connect them all, even though they don't have physical evidence that they were in all of those homes, because that's their MO. And so they can introduce evidence like that if he's involved with the crime. That's it. Okay. So I get it now.
But the 2010, 2011 convictions are before the RICO charge is 2013 to 2021, I think. So, yeah, but I understand the fight. I understand why the prosecution wants it in, and I also understand why the defense.
I can make an argument. Okay, so let me make an argument. We need the 2010 or whatever charge to show that he was a felon in possession, and then we need the later charge where he was involved with a gang, because we want to show some sort of modus operandi, or the fact that he runs with gangs and things like that. And so you need at least two of them. I don't know what the other two are, but I would have a good argument that you need at least those two. And then if the judge we're well, what if they don't believe? That's going to be us. Just take judicial notice and call it a day.
And Your Honor, I appreciate you hearing me out.
No problem.
And there's one other issue that we could take up, but while the jury's out, we might as well now. There's a photo that the state has indicated that they wish to admit, likely through a witness this afternoon. It's 26Q. It's been previously marked as 26Q. Your Honor, I would just describe it. It's a still up of a body cam.
Can I see it? No need to see it.
And Your Honor, to add context, in this incident that we're litigating this afternoon, my client is alleged to have been involved in a car wreck.
Okay, what is 26Q?
That is the driver. Apparently, after the wreck, the police dragged the body. He's alive, obviously, but they dragged the body of the man from his car and placed him on the grass. And they didn't know if he had any spinal injuries, which he didn't have. And they told him to lay there on the grass and remain still. And so I think that's a depiction of the man laying on the grass, remaining still. I don't know why we need a picture of the man who was driving the other car, laying in the grass, remaining still, following orders. I think it gives
on the phone or something like that? Or
I think he's talking to, in the body cam, I believe he was talking to a friend. But I think it gives the impression that this man was seriously injured and potentially can't move, which wasn't the case. And I just don't see the state of this man that was unfortunately in this car accident.
The car accident is a part of the RICO charge. It's him driving a car without a license, and I think they found a gun in the car.
That has absolutely nothing to do with what we're litigating today. I don't see how a hit and run, first of all, I don't think it's even relevant to a hit and run, but to the extent that it is, certainly a hit and run would not be, I don't think even the state would argue that that would be in furtherance of any RICO conspiracy. So I believe that
hit and run, okay.
I didn't say anything about.
So are you saying it's relevancy? Is that what
Okay, so this is not the gun in car thing. Okay, so this is just a hit and run. As an underlying act in the RICO charge.
I don't get it at all.
No, me neither.
has to mean?
403, yes, it's confusion.
No, that's different. Right.
It doesn't have any relevance.
Relevant is a threshold issue.
Okay, it doesn't have any relevance.
Okay, all right. State, anything as to 26 Q or Quebec?
Yes, Your Honor. For 26 Quebec,
the state feels that it is relevant. The previously admitted 23 Quebec and 24 Quebec would show this white Ford Fusion. Mr. Montgomery was the operator of that Ford Fusion. The state, that picture is just him laying on the ground, Your Honor, as you can see up there on his back. The state's not trying to get into whether he had some kind of back injury or spinal injury. It's specifically to corroborate what already Officer Cogdell has testified to and what Officer Raymond, who the state tends to introduce that through, that there was two cars and there's a diagram of this intersection that the state tends to introduce, which is 27 Quebec. And so the state just wanted to have the jury to be able to visualize the driver of the other vehicles.
Oh, bullshit. What a crack of bull crap.
How is a hit and run part of a Rico trial? Unless it was like the other gang and they were trying to whatever. I don't know. I don't know enough of the facts.
No, the car used in the hit and run is a car that has the prosecution alleges has been involved in crimes. And then
Is this
in a
one
hit and
missing
run.
the back seat, or is that a different case?
That's a different case.
Okay.
Mr. Short, unless you have anything else, I'll preliminarily say that I'm going to admit 26 Q or Quebec, okay?
Thank you, Your Honor.
All right.
Of course he's going to admit it.
Yeah,
A
we know
man
what's happening.
lying on the ground, motionless. Because why not? In a hit and run with a defendant that may or may not have driven it. In a car that may or may not have been involved in crimes. Of course, a man lying on the ground is relevant. Why not?
As for states, 30 Quebec, 33 Quebec, 31 Quebec, and 32 Quebec, given the pronouncements of the court, I'm going to admit those. However, you have one here, should say state, let's see, that would be 31 Quebec, where you would need to redact or otherwise not include the revocation matter. Okay, so that needs to be stripped out anyways, but, and we can talk about that later anyways, because I think that
We can
there's
talk
a lot
about that
of
later.
outline papers that you probably have that probably don't have any, that wouldn't go out to the jury anyways. So I'll admit them, but I'll say that you will have to at some point in time later, unless you're going to show them to the jury at this point in time.
On one of those convictions, it appears that there's one of the old Fulton County handwritten sentencing sheets, and then also the computer generated sentencing sheet as well. So it's almost like it's double, it's the same conviction twice. I believe that's on the game days.
I think that is another matter that we have no problem hashing out with Mr. Sharp prior to that document.
They're not even in front of the jury. They're just arguing about everything.
Yeah.
How are we progressing in the trial?
Otherwise, we would address it at a later time with the court.
Is
Are
the
you going to
prosecution
move it
waiting
anyway
to
to,
answer that and the defense trying to be doing things in good time, as the judge sometimes says? Why didn't you bring that sooner? Well, because you told us you would handle it later, and then it's later, and then it's too late, and he will admit it because the goalpost meanwhile has been changed. Well, more or less nothing else happened that day.
I was going to say, it's got to be like 2 a.m. your time, right?
Yeah, and I'm having the morning off, so I'm going to do a bit on the Texas v. Dykes after
Start
this.
streaming at like 4 a.m. our time.
Yeah, because we are starting with the defense case in chief, day 6 in the Texas v. Dykes, because, the Fox 4 Dallas cut out the audio where the state rested their case on day 5.
Nice.
Yeah. And so we will be hearing the motion of directed verdict and then the first few witnesses. And then I will save when Lisa Dykes takes the stand to a later day.
Cool.
Yeah. Yeah, but nothing else happens this day. So And tomorrow might be.
So after taking like 2 weeks off because a defendant was injured,
yeah,
they could have argued this stuff, right? In those 2
Not
weeks.
if- well, during Christmas, yeah, probably. But
could have
then
argued this stuff
only
during this
if
whole
the
thing.
defendant, because if the defendant says no, I want to be there, then they don't have much choice.
Yeah, okay. Give them a Zoom camera. I mean, come on.
Yeah. What is this trial about? This is about Fannie Willis going for the Attorney General position later this year in that election. Because a huge RICO trial 3 are much better than giving hundreds of victims and hundreds of defendants their day in court. Because this is televised. This is what they
trial's
try.
about a guy who always uses cap locks. Jeez, on the internet, Lefty just chimes in there. One day he's going to start streaming again. I think. I don't know. But yeah, no. Essentially, so there's a rap group that's being charged with RICO because apparently they can't get them on anything else, but they suspect that they're involved in, is it 3 unalivings or just the 1?
I don't know.
But they can't really tie anybody to this stuff. So they're trying to charge everybody and say that it's like a big, giant thing. And anything one does is attributed to the other. And it's a giant mess.
Yeah.
He's not going to say it. That's okay, Salvador.
No, I don't need to.
Yeah, it's up there for the world to see.
Yeah.
It's a remnant from our Jody trial earlier today that you missed, sir.
I listened to it and I heard how much you hate that.
Such a stupid phrase. I shouldn't have called it out because it wasn't even on the stream. It was from the other day.
Yeah. By the way, what's that under MLS, Dave?
What?
On your text.
Oh, God. Let's say hi to Scotty. Oh, that's awesome.
All right.
That's me.
Yeah. All right, folks. In 7 minutes or so, my next stream will start. I will be sending you over there from YouTube's. It will be on Rumble as well, but I can't have 2 streams. I can't put up the next stream on Rumble because they only allow 1 stream at a time. So I have to create all of that.
Mm-hmm. Rumble needs to work out some kinks.
Yeah, they really do.
Mm-hmm.
But thanks, Dave, for showing up.
Yeah, no problem. I'm gonna go make myself some dinner now.
Yeah, and chat and everybody. I'll see you in a few minutes, and we will be doing the first the directed verdict motion and the first couple of witnesses on the Lisa Dykes trial. And
nice.
Yeah, so I'll see you all in a few minutes. Thank you all for showing up, and I'll see you in a few minutes. Bye-bye.